Okay. We don't have a list. We're gonna have to just
First will be up with plates in just 2 seconds.
Cool.
Oh, okay. Oh, well, there's they're all the dried.
My Siri on my phone. Something elegant. Still working. Yeah. Still working.
I know, right? We gotta kind of shut it off. There we go. Make sure you stay
You're like a 7. Of all the different iterations, right? You probably have every hat. I have every hat. Do you? I have every hat. I missed the first. Should I do it right now? Hand it out? But it said make HOAs great again.
Okay, that's pretty good.
It was pretty good. Train the brain of my wife. I'll start on this side and I'll get on this side. I'll see you in a minute.
Okay.
Yeah.
Everybody, I think we're going to get started. We are sure glad to see so many of you here today to learn about why you know, HOA living, what we do for a living. We love good communities, and I'm sure you do as well, and that's why you're here. We're going to learn a lot of stuff today, and hopefully it'll be interactive. That's our goal. So if you have questions, feel free to raise them. We passed around a quiz. Okay, we're gonna let them do that up front.
Yeah, we're gonna have to do it in front.
Yeah, we're gonna let you just take a few minutes and go through that quiz, and we're gonna have a little giveaway for the 4.
Just the top.
The top
points.
The top points is going to get a gift card to Megaplex Theaters. Okay, so keep that in mind as you're going through that quiz. while we're doing that, why don't we just kind of introduce ourselves? We're attorneys with the law firm of Miller Harrison. We specialize in community association law. And I'm Michael Miller. I've been practicing in this area for about 13 years almost. And between us, we represent hundreds of different associations of all different kinds throughout the state of Utah. And we do these trainings. Thank you. That was a lot. That makes it easier. These trainings, we hope, are helpful. We enjoy doing these and getting to know people. I'll let you guys want to introduce yourselves?
Yeah, absolutely. So my name's Tyler Lamar. My entire legal career actually has been focused on representing HOAs. So we consider ourselves HOA nerds. We represent the developers, the owners, on occasion, and boards, represent a lot of boards. So any topic that you would like addressed today, nothing's off limits. We're happy to address whatever comes up. Ready to answer your questions.
Good afternoon, I'm Peter Harrison. Excited to delve through this quiz with you today. Super straightforward. Everyone in here should know every answer, at least split. And excited to get to know you a little bit better and answer any questions you might have.
Hi, I'm Doug Shumway. I've been with these guys for almost 4 years, but like Tyler, HOA law has been the only law that I've practiced in my entire career. And in conjunction with this little pop quiz that we're going to do, the top 5 scorers.
It'd be tricky to take questions.
That's right. Top point earned. We have some Megaplex gift cards for you. So do your best. We understand some of them are tricky. Some of them are intentionally a little bit confusing. That's a point of discussion today. All right. Well, should we just give everybody some time?
Yeah, let's.
Why don't we?
Few minutes.
A few minutes. Go through it. If you have some questions about it, we'll address those. Thanks.
I'm sorry, I failed to recognize Sarah in the back. She keeps us organized.
On time.
And on time. And was the order of the food that you're eating today. So we appreciate Sarah. If you need a little more time, want to raise your hand, don't be bashful. I'm the slow test taker. Nothing wrong with that. You good? Okay. We'll get started. So what we're going to do, we wanted to make this interactive, so we'll kind of go through the questions and then have some discussion after each question. Those questions are written to create some dialogue among us and talk about some of those topics. So one thing, it's always a good icebreaker, I think, is to talk about HOAs getting sued. I know, we don't want that, but it happens, okay? I have a small claims trial tomorrow on an issue like this. Guy alleges that the HOA common door swung closed during a windstorm and knocked out his tooth. So he sued the association to have that tooth fixed, and we have a little trial tomorrow on that. So these are the most common lawsuits that an HOA faces. Failure to maintain, repair common property. This comes from CAI, which is the largest trade organization in the nation that concentrates on HOAs. Both from an owner perspective, a board perspective, a developer perspective. So this comes from them. They track litigation across the country. In fact, as members of CAI, we get an email every month from them identifying for us the cases that involve homeowner associations. Failure to properly notice and hold meetings. We're going to talk about that today. Failure to collect assessments, HOA records disputes. We're going to talk about that today as well. Record requests are becoming more and more common, and laws are evolving in that area. Improper budget management, failure to adequately fund reserves, negligent hiring and supervision of agents, improper fines, and the selective enforcement or non-enforcement of covenants. So again, we're going to talk a lot about most of these during our presentation, but just kind of wanted to bring that to your attention to get us started. So let's go to question number 1. What is the answer? Anybody want to raise their hand and be brave enough to holler out their answer to that question? B. Okay, so to select the proper hierarchy of HOA governing documents. B is plat and CC&Rs, articles, bylaws, and rules and regulations. That is correct.
Got one right.
Now we're trusting the honesty policy here, right? Or should we pass them over to your neighbor and have the name now? I'm just joking. But, okay, so how many of you, just curious, I think most of you are probably non-condominiums today. Are any of you here or you live or a board member within a condominium project as opposed to a non-condominium or PUD? Any condominium owners here? Okay, good. Okay, good. So what we have in Utah is we have 2 different acts. We have the Utah Utah Condominium Ownership Act that is specifically is limited to condominiums. For anything that's not a condominium that is governed by an association, we have the Utah Community Association Act. Very similar. There are some differences, but similar in many regards. Second to that, we have the Utah Revised Nonprofit Corporation Act, which my partner will talk to you a little bit more about in just a minute. And then we get to what are the governing documents of an HOA. On top is the declaration and plat. They are to be read, there's a Utah Supreme Court case, together to the extent possible. That's why they're equal on the hierarchy. Underneath the declaration and plat map are the articles of incorporation. The declaration and plat map are recorded with the county recorder. Articles of incorporation are filed with the Department of Commerce, Division of Corporations and Commercial Code. Bylaws are also recorded with the county recorder. They contain kind of the operational provisions for an HOA, things like how many board members are there, what are their qualifications, what's the core requirement for board meetings, what's the core requirement for owner meetings. And then we have the rules. The rules are not recorded, but they're a document that the board, we're going to talk more about rules, can typically adopt on behalf of the association to further define the declaration. You know, for instance, the declaration will say something like, every owner is guaranteed the quiet use and enjoyment of his or her property. Well, that's a good statement, but what does that mean exactly? So the board, through the rules, can say, well, we interpret that as meaning that between the hours of like 11 p.m. and 7 p.m., the neighbors should be a little bit more quiet. Or 7 a.m. Did I say p.m.? Yes. 11 p.m. 7 a.m.
Quiet going on there.
Yeah, for sure.
Party time only for dinner.
That's right, that's right. So that just kind of illustrates, kind of the play between the CCNRs. CCNRs might say something like, you can have up to 2 4-legged animals in a lot or a unit. And then it might say something like, and the board can adopt other rules. So the board and the rules might say, you know, poop has to be cleaned up immediately, you know, or it has to be leashed within the common areas. So that's kind of the play between those documents. Any questions on at least the hierarchy? If not, we'll move on to question number 2.
All right, question number 2, the hardest question on the quiz. HOAs are required to register as a nonprofit corporation under Utah law. True or false?
True.
By a raise of hands, how many think it's true? Oh, you're all wrong. It's false. It is false. There is no requirement that your HOA be incorporated as a nonprofit corporation. The reason that this is added here is because almost every single one is. Why? Because it's great policy to be incorporated as a nonprofit entity. Okay? There are actually multiple HOAs that are incorporated as limited liability companies, which is bad for 2 reasons. One, the Utah Revised Nonprofit Corporation Act, it's this gap filler between what the code, between if you're in a condo, the Condo Act, and a non-condo, the Community Association Act. So the Community Association Act has only been around since 2004, and when it was initially drafted, basically all it talked about was assessment collection, okay? It's been refined repeatedly over the years, refined and expanded upon, but there are still multiple gaps. So the Nonprofit Corporation Act does a great job of filling in those gaps, and especially if you're on a board of directors, it's very important because it provides all sorts of statutory protections. So,
Real quick, I'm gonna do something impromptu. Bonus gift card for the first person that can answer true or false. The first condominium in the nation is found in Utah. You know what, the first one to answer this gift card. The answer's true, actually. So, no, I guess nobody gets this.
we'll do it again. It's true.
It's true.
It was found in
Greystone
Utah.
Manor, actually, is the first condo in the country was in Utah.
1964,
Yep.
I believe. Okay, when Tyler was born, that's why he remembers that. We're talking about nonprofit corporations. Okay, so real quick, as Michael said before, when you file your articles of incorporation, so when you incorporate as a nonprofit entity, you have articles of incorporation right here, and those are filed with the Department of Commerce, okay? And so if you just were to Google Utah Business Entity Search and type in the name of your HOA, it will pull up there, okay? Because you filed articles of incorporation as a nonprofit entity. And we don't have this question on this quiz, but there's actually another body of the Department of Commerce in which HOAs are required to register, and that's the Utah HOA Registry, okay? And the point behind that is that the title industry a handful of years ago said, whenever a unit closes and they're in an HOA, we want to know who the contact is. So if you get on to the Utah HOA Registry, you're required to update that whenever your board changes. And you're supposed to have the contact information for your manager and your board members on there, okay? So that needs to be updated if you have annual elections and your board changes annually. It needs to be changed every single year, and there are big penalties if that isn't updated. What it does is it renders the HOA's lien rights null and void. So it's important to be updated, okay? So 2 different filings, you have to do them basically every single year. The Department of Commerce for your renewing your business status, a nonprofit corporation is a business, and then the Utah HOA Registry to renew your HOA status. Okay, number 3.
All right, number 3, HOA board meetings must be open to the membership. A, for any board meetings held during the period of administrative/developer control or declarant control. B, for any board meetings held after the period of administrative declarant control and at least once a year during administrative declarant control. Or C, at all times regardless of who controls the HOA. Anybody wanna throw out their answer? Did I hear C?
Yeah.
Anybody else? B? Okay, the answer is B. So, after the period of administrative control, you absolutely have to have all your board meetings open to the general membership. Not to the public, but to the general membership. And then at least once a year during the administrative control. Now, there's a little bit of a nuance in the statute that requires this. It specifically defines what a meeting is. A meeting is only a meeting for purposes of the open meeting statute if it's a meeting at which the board can take action. The official definition of what a meeting is, right here. Whether in person or by electronic communication at which the board can take binding action. So sometimes we have board members call us and say, hey, we just wanna talk. We wanna meet together and talk about some things and maybe talk about how some of the issues in the community and maybe we have an upcoming board meeting. As long as that meeting is not one where you're taking binding action, arguably you can say that's not a meeting for purposes of the open meeting statute. So homeowners, you can close that to homeowners. But if it's a meeting at which binding action can be taken, it has to be open to the homeowners. Any questions on that? Sure.
What do you mean by after administrative control?
Yeah, excellent question. So administrative control, according to the statutes, both the Condo Act and the Community Association Act, the non-Condo Act, define it that when the developer starts developing a community, that development entity is the board for a certain amount of time. They can appoint who the board members are. At a certain point in the construction, and your CC&Rs will usually dictate, if not, there's a default in the statutes. After, let's say, for example, after 75 units are built, or after X amount of years after the CC&Rs have been recorded, it'll dictate that control has to be turned over to the homeowners. So now it's homeowner elected board, not developer appointed board.
Where are we in that process?
Good question. I'm not sure who we are, sir. Daybreak, yeah, okay. So, but some of you are here on behalf of sub-associations, correct? So you've got your master community, that HOA, and then you've got a lot of sub-associations. Right? So the master is still under developer control, and it probably will be for quite a while.
But we have over 25% built out.
Okay.
We have our first voting board member that was voted on.
Okay,
As the
right on, great. So the governing documents, oh hey, right on, great, excellent. So your master governing documents will likely dictate when turnover needs to occur, and that's gonna be at a certain amount of percentage of build out. If you're at 25% right now, how long have some of you been living here? Who's the oldest member here living in Daybreak?
14 years.
14 years, okay, so at 14 years, you're at 25%, so to get to maybe 75% or whatever the 75% is the turnover date, or the turnover time, so maybe next year? Yes, sir.
Where does the concept of executive session fall into?
Yeah, great question, so, oh, yeah, I don't wanna step on anybody's toes, but yes, we're gonna address that. You can, adjourn into executive session.
Yeah. So, I think I'll just add too that what we're seeing today, even though we're under administrative declared control, this is phenomenal. This is not something we typically see, that during a declared control period, we gather homeowners together, we allow a voting member from the community, and we talk about best practices for HOA. So it's a great thing that we like to see, that's really uncommon, and we don't often see developers facilitating during this time. Okay, we're gonna answer this question by setting, the question that was raised in the back, by setting up number 4. An HOA board may take action without a meeting only if A, proposed by the president of the HOA, B, a majority of a quorum agrees to the action in writing, C, not prohibited by the governing documents, and 1, the action is unanimously approved, or 2, properly proposed to the full board and approved by quorum and no objection is made, or D, taking action without a meeting is no longer allowed ever under Utah law. Anybody want to venture a guess on this one, or does anybody know the answer on number 4?
Let's say C.
Okay, we're hearing C's, D's. C C is the proper answer. So
The
Utah.
voting board member.
Yeah.
Way to go.
So this is a common pitfall for HOA board members, okay? The reason for that is oftentimes emails are a very convenient way to connect with other board members to try to keep things moving. It's hard to get everybody together. After all, you're usually a volunteer on these boards. It's hard to set aside time for meetings. Things need to get taken care of. So we often see people fall into the pit of saying, hey, we got a majority responding back to the email, let's go for it. In Utah, that is not permitted, okay? In Utah, to be allowed to take action without a meeting, first of all, your governing documents must allow it. And many historical documents in Utah do not allow any action to be taken outside of a meeting by the board unless by unanimous consent, okay? That was recently updated, and we now allow it to be done, but only if it's either unanimously approved or if an action is proposed and we tell all the other board members the deadline by which they must respond and no one objects. So at any point in the process, any board member could say, you know what, this is an important thing, I don't think we should be doing this outside of a meeting, I object to taking action without a meeting, and that will trigger the requirement to only take action inside the meeting. If no one does that, and and you don't respond by the deadline, it's presumed that you consented to the proposed action. You may even respond and say no, and the majority of the board would take it, and that would carry. So if no one objects and a majority approves, then you can take action without a meeting. Now, question was raised. What do we do about executive sessions? Can we do an end around just by getting the board together and deeming it an executive session? Under the act in Utah, there are limited reasons to go into executive session. But if you look under the statutory provision that allows for it, it only allows you to do so if you are discussing and consulting on various items. There is no action that may be taken in an executive session. So you're allowed to close it down to consult with a lawyer. You're allowed to close it down to talk about something that would cause embarrassment to a personnel member or a member in the community. You can close it down to discuss contract bids. Maybe you don't want the people that are bidding on a project to come hear a review by the board of what their competitor is offering. So you can close it down to review bids together. There are a limited number of items that where you can go into executive session, but action should not be taken in executive session. You must come out of executive session. Action should be taken in an open board meeting or properly without a meeting, and it should be documented by the minutes. Right, so Doug raised another point. We often see board members taking copious notes during executive sessions. That's a mistake, and it defeats the purpose of going into executive session. Because as we'll talk about later, there are records retention and records request rights, and if we're trying to keep something private and limited to the executives, it defeats the purpose to take minutes on it, which would then be susceptible to being requested by an owner and reviewed pursuant to that right.
Thank you. All right, now we are on to number 5. Notice of board meetings must be provided to all owners within the community prior to the meeting, any owner who has opted out of electronic communication, any owners having requested notice prior to the meeting, unless a prior meeting schedule has been adopted and published, or D, any owner who is likely to sue the HOA.
Yes.
Yes, yeah, you always want to notify that owner, right? Okay, what's the answer? Who says it is A? Okay, not a bad answer. Maybe not the right, the most correct answer, but it's a good answer. B? C? Good. And anybody B? Okay, all right. The answer is actually C. It's the most correct answer, okay? Let's explain why. Number 1, A, which most of you put, all owners are actually not entitled to notice of meetings in advance.
They are if they request to receive notices prior to meetings. But they have to formally make that request. I should mention this as well. Most of these requirements, at least with notice, are not required in a developer-controlled association. So the developer, there's a caveat I'll explain. The developer-controlled board does not need to provide notices to meetings, except they do need to hold at least one meeting annually that is open to owners. And every time the developer-controlled board increases fees or raises an assessment, that meeting needs to be open to members. But absent that, there are no meeting requirements for a developer-controlled board. Yes, sir?
Don't most bylaws though have a section in there that declares you must make notice within so many days before?
They do sometimes. The bylaws will provide that sometimes. But typically, I see that more of the notice that to the other board members. Sometimes it is with the owners. Yeah, this is a fairly recent occurrence, believe it or not. Like, I think this, I can tell you, 2015. Prior to 2015, board meetings could be completely closed to the owners. We never recommended that, but that's how it was. So a lot of the older pre-2015 bylaws, I bet, won't mention that. But the current ones will have provisions like that. But these are often referred to sunshine laws, and this is the direction our state is going, is to make board meetings open. And now, they haven't gone completely for a developer-controlled board, but certainly if you are an owner-controlled board, your meetings need to be open. Notice has to be sent at least 48 hours before the meeting begins, or if they're posted like on a community website, or if you send out a newsletter and post the dates, and that's considered sufficient notice to all owners, even those that request notice. One more as well, if it is a meeting that the board has that's required to be open. If board members participate by electronic means, like through a conference call, then that conference number has to be distributed to owners, and owners have to be given that same right to be on the call. So keep that in mind as well for these open board meetings. And I think that's, any question on board meetings? Okay.
And we're halfway done. Okay. This next one, in my opinion, is the one that leads to the most litigation among associations, and that is the request of records. So, 6, the question is, an owner is legally entitled to inspect association records by how many, said A, requesting them at an open board meeting? No one. What about B, filing a request to the Utah Department of Commerce? Okay, wow. C, request to the manager, whether in person or by phone. How many said D? The wrong answer. Request to the association, but only if in writing. That is actually the correct answer. So, both the Condo Act and the Non-Condo Act have adopted provisions from the Utah Revised Nonprofit Corporation Act that deal with records requests. But this is actually very extensive, an owner's ability to request records. And there are certain documents that an association always has to have on record, and I'm not going to list all those because you can look in the Revised Nonprofit Act. It's titled 16-6A-1601, which will list out those. 1602 will actually list those out. But an owner can actually request any record that the association has, so long as they make the request in writing and explain what their good faith and proper purpose is for reviewing those records. Okay? So this is why it's super important when Tyler talks about like taking minutes during an executive session, that if you have a really disgruntled owner who you might be talking about in executive session because they threatened to file a lawsuit against you, and then you've taken copious notes about the discussion that you just had with your lawyer, and those somehow become now part of your association records, they would now be entitled to those records. Okay, so it's, you gotta be very, very careful when you're sending, for instance, emails among board members and you're conducting association business. Technically, there's a very good argument that those are now association records. Okay, so you need to be very careful with email. You need to be very careful with the minutes that you're taking. When you take minutes, they're called minutes for a reason, not hours. It should be very short and concise. Basically, the subject matter that you're discussing, who according to Robert's rules is calling for votes, and how the voting actually occurred, rather than, sometimes people love to be very thorough, so they'll record the board meeting and then they'll make a transcription of everything that was said at the meeting. Bad idea. Don't do that. Don't record your meetings, and don't transcribe your minutes, okay? The minutes should just be very straightforward as to the business that you're conducting at the meetings, okay?
Who pays for the records when requested?
Yes, so who pays? Sometimes there are costs associated with those records, right? Lots of times an association website will just have those records on hand, so it can be very easy to get board meeting minutes, financial records, association documents, the governing documents. But sometimes the records requests can be very extensive, multiple page requests that ask for everything under the sun, and now you're having to go out and dig through some boxes or look at an old server to track those documents down. And basically the act allows for the association to charge reasonable expenses incurred in tracking those documents down, and the owner requesting those documents needs to pay for them. And this is a copy cost. Now, the big penalty is this, is if you receive a records request in writing, you need to get on that real quick, because, especially if it's from an attorney, because if you fail to respond within 5 business days, and they then send you a follow-up, there's an attorney fee penalty, okay? And it's $25 a day as a penalty for every day in which you don't provide the records, and reasonable attorney fees, okay? And then once they send you this 10-day right to cure letter, you have a right to cure within 10 days before they can file a lawsuit, but you're still on the hook for their attorney fees and the $25 a day penalty. I'm actually going through that experience right now with an association who is unwilling to turn over records. So the bottom line is this: if you receive a records request, be very diligent in making sure that it's complied with. If they're asking for things that you're not sure whether or not they need to be turned over, which is actually very common. One of our associations just got a records request, and it asked for any email communication between our firm and the board of directors. Is an owner entitled to that information? All of you should be shaking your heads and saying no. That's called attorney-client privilege, okay? So, there are lots of times lawyers ask for documents in which they know they're not entitled to, just to see if you will give them those records, okay? So, if you get a request, talk to your manager, talk to an attorney, and make sure that you're, one, that you're giving them the documents that they're legally required to have, and two, that you're doing it in a timely manner. Okay.
All right, let's test the waters a little bit. Does anybody have all 6 correct so far? Anybody with 5? All right, 4? Excellent, okay. Well, let's keep going. Number 7, reserve study. A reserve study must be conducted after the developer control period. A, no less than every 2 years. No less frequently than every 6 years, no less frequently than every 3 years, or at an interval determined by the reasonable business judgment of the board. Any thoughts on that? A. Okay. Anybody say B? Okay. Got 2. Anybody say C? Okay. And D. All right. The correct answer is B. No less frequently than every 6 years. Now, this is after the developer control period, so homeowners are now in charge of the board. And what the statute says is you have to conduct the reserve analysis every 6 years and review it and maybe update it every 3. So every 6 years you actually conduct the reserve analysis. Every 3 years though, you review it at least. Now, you have to provide, this isn't in the quiz, but once you do that, every 6 years or every 3 years, you have to provide that summary to the owners every year. Usually that's in conjunction with your annual meeting. If it's not, as long as you're sending that to them sometime within the year. You have to provide the full study when it's requested by an owner, so that's one of the HOA records. If a homeowner requests that and gives you a good faith, proper purpose for wanting to see it, you do have to provide a copy of that reserve analysis. Now, some boards are hesitant to give that information. They don't want the homeowners to see what the reserve analysis says because maybe it says you should be putting X amount of money away every month towards your reserves. And some boards get a little bit nervous about letting the homeowners see that because maybe they aren't doing that because they're financially strapped or for whatever other reason. But ultimately, the reserve study analysis is an HOA record and it can be made available to the owners who request it.
Doug?
Yes?
On the reserve, the amounts or percentages, isn't that a legal requirement?
That you actually fund it?
Yeah, fund it.
You're leading us out into our very next point. Thank you.
Oh.
I'll pay you later.
No, that, my question
Have
came
witnesses.
up because if a board is reluctant to show it to the owners, if it's a legal requirement, why would they do it?
Yeah, it's a good question. So here's what the legal requirement is. The legal requirement is that you have a line item on the budget for reserves. There has to be that line item, but here's the screwball thing. The statute does not require that you actually fund it. You need to have a line item, and maybe it says 0, or maybe it says $100, or maybe it says 10,000, whatever. The statute requires you to have that line item, but the statute does not require that the HOA actually fund it. Now, understanding that, let's step back a second. If a board has a reserve study that says you should be funding up to X amount, and they decide to fund it 0 amount, just because the statute doesn't require it, that might be a breach of a fiduciary duty that the board owes to all the community, right? To say, hey, there's a professional here who says you should be funding X because your roofs are this type of material and need to be replaced every 30 years or whatever, and you fund it 0. So just because the law, what's that? Right, it also might not be, you're right. But just because the law doesn't require you to actually fund the line item does not mean, great, awesome, we don't have to, right? It's something that should be addressed.
I thought that the law also required them to actually fund the reserve fund, not just
Nope.
make the study, but they actually have to do it.
You don't actually have to fund it.
Not in Utah.
Not in Utah. Now, when you say the law, it's not the Condo Act or the non-Condo Act.
Utah state law.
Utah state law does not. However, FHA, if you want to get certified under FHA, you're a condo and you want to get FHA certification, which a lot of buyers want because it opens up your buyer pool, right? Instead of getting a conventional loan now, you get an FHA loan. FHA does require demonstration in the financials that money is being put away for the financials, but it's not a requirement under Utah law. So, but here's a little nuance to that. Let's say a board gets a reserve study, they've got their line item on the budget, and it says $0. Within 45 days of the board presenting that budget to everybody in the community, the homeowners can rally and get 51% to vote to veto that $0 line item or that $1,000 line item. Or maybe the board is a little too zealous and they say $100,000 or whatever. And the community says, whoa, we disagree with that amount, either it's too high or it's too low. The community can rally together and vote and completely veto that line item. Curiously, that's the only part of the budget that the owners can have any say in. The owners are not allowed to veto the whole budget. The statute only allows homeowners to veto the reserve fund line item. Okay? Anyway, there we go. 45 days, 51% vote. So there is a penalty for not following this. If you don't do your reserve study every 6 years and you don't do a review every 3 years, you don't provide it to the homeowners. Again, similar to the records request statute, there's an automatic $500 penalty plus attorney's fees.
Penalty that goes to who?
Goes to the owner,
Brings the lawsuit.
whoever brings the
Oh, I
lawsuit.
see.
Yeah.
Oh, yeah.
So if a homeowner says, whoa, you didn't comply with the statute, you didn't do the reserve study, you didn't do the review, you didn't provide it to the owners, I'm suing you to enforce that. Automatic penalty to the owner. So it's kind of a windfall, right? Not only do they get their attorney's fees, but they get $500 on top of that.
Cool.
Okay.
All right, number 8, true or false. This next section, actually, we're gonna be talking about rules and fines. This is just one example of a rule that may or may not be able to be adopted. 8, an association may restrict the minimum term of a lease or rental by rule. True or false? How many say true?
True.
Okay, how many say false? Okay, true is taken. It is true. Now, this actually comes as a surprise to most people that are managers or lawyers within our industry. And the reason I say that is to restrict the number of rentals within your community. It must be done in the CC&Rs, okay? So if you want to put a cap on how many rentals, it has to be done in the CC&Rs. If you want to do a cap or a minimum lease term, it can be done by rules, okay? Now, obviously, this is a hot button issue with VRBO, Airbnb, vacation rentals within communities. It's very controversial. Some associations are very against it, some have embraced it, and in any event, it can be addressed by rule. Now, yeah, we have a question back here.
So the condos have the same rules?
Same thing applies to condos and PUDs. Now, as Michael mentioned in the very beginning, we look at a hierarchy of governing documents because your rule cannot conflict with anything higher in the hierarchy of documents. So if your CC&Rs say there's a minimum lease term of 6 months, we cannot by rule make it more restrictive, right? It would be in conflict and the CC&Rs would govern. Keep in mind also that anything that's done by rule is subject to change with the change of the board. So it's less permanent, it's easier to change a rule than it is to change your covenants, which usually require a supermajority vote of the membership. So this is one example of rule-making authority provided in both the Community Association Act and the Condo Act. Michael is now going to talk a little bit. He's going to quiz us on the adoption process for rules in a non-condo PUD.
All right, another somewhat tricky question. Number 9, HOA rules may be adopted by a board of directors without the approval of the owners, but only in a PUD. You're going to see there's a distinction, PUD being planned unit development. We should have specified that. A non-condominium. Because of that oversight, I will give you 3 seconds to change your answer. 3, okay, locked in. All right, B, a board of directors with the approval of no less than 50% of the owners, but only in a condo. C, a PUD board of directors, but only after 15 days notice of proposed adoption and holding an open board meeting. Or D, a condo board of directors, but only after 15 days notice at an open board meeting. C. How many have C? Okay. How many have A? B? Okay, the answer is C. This is where we, as I mentioned kind of up front, the 2 acts, the Community Association Act and the Condo Act, are similar for the most part. They're getting more and more similar. This illustrates one of the key differences. So if you live in a condominium association, I think there's only one gentleman here that does that. Board members can adopt rules. without any meeting of the owners. I mean, they're free to adopt them on their own. I mean, yeah, sometimes it'll be done in an open meeting,
Yeah,
but.
it doesn't require an owner meeting or prior notice.
Yeah, it doesn't require prior notice. The board just puts the rules together, and so long as they are not in conflict with the higher documents, being the CCNRs or bylaws, then those rules are valid. And only the board can overturn those rules in a condominium. In a PUD, in a non-condominium, which is most of you in here, it's a little different. Board members can still adopt the rules, but they have to send out notice to all owners 15 days in advance of the meeting and say, on May 30th, the board will be meeting to discuss, revise, or create rules for the community. You are welcome to come and be involved with that discussion. So that notice goes out to the owners. The owners can show up to that meeting, and they need to be given an open forum to discuss the rule changes or the creation of the rules, whatever the board's doing. For a certain portion. So typically how I've seen these meetings work is you kind of open it up, you kind of hand out the rules, the owners can ask questions, voice concerns, then the board says, okay, we appreciate your feedback, now it's our time to deliberate. And the board ultimately has the final decision on the rules. Yes, sir.
I don't remember reading in our CC&R's differentiation that says here's the rules versus the condo agreement. Is there a specific rule?
Yeah, what you're likely to find is the rules won't be in the CC&Rs, but within the CC&Rs, you'll find a provision that will say something about the rules, like the board is authorized to adopt rules for the association. And sometimes they might see some limitations on that, but typically it's up to the board to make those rules. But again, in a PUD setting, there is some protection because they hold the open meeting, owners can offer comment, and then once the rules are adopted, the board has to send them out within 15 days of official adoption. And then the statute does give owners the right to veto those rules with a 51% vote of all owners within 60 days. Correct, thank you. Now, I don't think that applies again to a developer controlled association.
Well, so what the statute says is that the declaration can exempt them
That's right.
from that process, but it must be affirmatively addressed in the declaration to exempt them. So if it's not addressed, then it does apply even in a declared control period.
Does that make sense? So the developer controlled association can be exempted from following that process if the governing documents allow that. If they don't, then they need to follow that process. So the PUD setting just gives owners, a few additional rights and an opportunity to veto ultimately what the board adopts. Any questions on that part? Okay.
All right, my favorite subject, fines. And our last question. I'm going to give everyone a big hint. The answer is not B. So if you mark B, you've got 5 seconds to change your answer. B is wrong. And with that, an HOA may levy a fine. How many people think it's A? A seems like a reasonable answer.
But
Reasonable. How many people think it's C? Only in a specific amount and for a specific violation listed in the association's documents. Only 2 people think it's C. Only 2 of you? Oh, maybe 3 think it now. Okay. What about D? Oh, all you D's? You would have got a D in school. You're wrong. The answer is C. C. Now, statutorily, if I am fined, guess what? I have a right to an informal hearing. So why is the answer not D?
Yeah.
Because I have a right to an informal hearing.
Don't have to get notified.
I do not have to be provided with notice in the fine of my right to an informal hearing.
But does that make D wrong?
Oh, you boy.
Yeah, it does. Because it says only in a specific amount with notice. So it's wrong. Because you don't have, it doesn't have to be.
If you want to challenge, there's an appeal process. And it's a board
You only had 5 seconds to do it though, and you missed that window, so we're disregarding that. Okay, so fines. Typically, associations, pursuant to their rule-making authority, okay, so rules before we just got done talking about that, right? Will come up with a schedule of fines, which would specifically list out, I'm just gonna use an example that Michael did earlier, dog poop, right? You didn't pick up after your dog's poop. So that is a fine. And we're going to fine in a reasonable amount that's specifically listed. So what's reasonable for not picking up your dog's poop? What do you think? $25 for the first offense. Should it escalate thereafter?
Yeah.
That would be reasonable, right? So on the second offense, $50, right? And on the third, $75, okay? So we're gonna have specifically listed amounts of money for specific offenses, okay? And before we start fining, those are going to, as Michael just said, if it's in a PUD, we're gonna send those out at least 15 days prior to this meeting. We're gonna have an open meeting. We're gonna talk about this with the ownership if they show up at our open meeting, okay? And if not, we're going to send it out to everyone. Hey, here's your notice. These are the things that we're going to fine for, okay? So, on my very first time, I'm a very irresponsible dog owner. I take out my dog. I let him do his business. Michael, my nosy neighbor, takes a picture, or better yet, a video of my activity, which I hear some laughing. Actually, very, very common to receive videos of people not cleaning up after their dog, okay? And he sends that to the board of directors. Okay, for that first offense, am I receiving a fine pursuant to this schedule of fines that we just did? Everyone should shake their head and say, no. Because the first one, guess what? I get a warning that says, hey, listen, you just violated this rule. And if you do it again, you will be fined. Okay? And from that point forward, there are monetary damages every time I do that.
What if I do it 366 days later?
Okay, Tyler's getting into some nuance here. So, if he does it 366 days later, guess what? He gets another do-over.
You get one
Okay.
free violation.
Every year, you get a do-over. Okay?
At what point does the PUD finally just get to shoot the dog?
Yeah, so here's the problem with that, is eventually, all these fines, but this is actually why A is a good answer. Reasonable, okay? Reasonable. At some point in time, most likely your lawyer is going to stand up in front of a guy or gal wearing a black robe. And what they look at is reasonable. Is this reasonable? So, is it reasonable to fine Tyler $500 because his dog pooped on the lawn and he didn't pick it up? Maybe. In some communities, that might be reasonable, okay? So it's going to depend on the community. Now, if he was living in a condo and we were fining him $550 for that offense, that would not be okay, ever. Because you can only fine $500 in a month for any given offense, okay? For any one specific offense.
Only in a condo, though.
Only in a condo, not in a PUD. Another one of the differences between the statutes. So, I hope we've learned a couple things today. One, I hope we've learned some substantive things, right? At least 10 substantive things. Has everyone learned 10 substantive things? Okay. Another thing that I hope that we've learned is that these things can be super complicated, right? Reading your governing documents, wow, it is amazing for curing insomnia. Pull out that declaration and start reading through there, and most people will want to take a nap within 5 minutes, okay? Because it's written by lawyers in really boring language, legalese, okay? And it's written that way for a particular reason, because there have been a bunch of court cases over the years that have kind of defined out what those terms are, and so we just play it safe, okay? The other thing that's really complicated are the statutes, okay? You could, depending on the association that you live in, you could, in this community, and living in Daybreak, you could be subject to the Community Association Act via the Master Declaration, okay? You could be subject to the Condominium Act if you live in a condo, and you're going to be subject, even though you're not required to, but I guarantee you that you will be, you're going to be subject to the Nonprofit Corporation Act, okay? So those are 3 statutes. That is this entire book, okay, of laws that you are subject to, okay? So it's super complicated. So my point behind all of that is this. There are people that specialize in doing nothing other than representing homeowners associations, okay? Rely on your managers. That's what they're there for, okay? If you need to get an attorney involved, get an attorney involved who specializes in representing your types of communities and can answer those questions, okay? We've taken up more than an hour now. It's our pleasure to come out here. We're super thankful for you coming here and showing up and talking about HOAs. Oh, yeah. Did anyone get 10 out of 10 on the quiz? What about a 9? Did anyone get a 9? An 8? 7? All right, we've got a 7.
Let's just see what else we got.
Any 6s? Oh, we've got 1 6. We'll get the 6 a gift too.
For sure.
What about the lowest? Maybe we should.
Did only one get a 1?
Whoa, there it is. That's courage for raising your hand.
We got 2. Did anyone get 0? Did anyone get every one wrong? No, we've got this gentleman right here who got a 1.
Yes, well, we have a couple more. Hey, that's like
I only answered.
golf, right? The lower number, the better.
All right. So with that, we will.
Feel free to come up and ask us
conclude,
questions
yeah.
if you have individual questions.
Thank you guys.